been doing this for almost 4 years now, where 270,000 people have tuned in. Kevin and Harry used to join us on other sessions. Kevin on the on the growth Q&A, and Harry on the employment, on the talent one. Ishita is new to us, but nevertheless, the idea is that for the next 57 minutes, these three brilliant lawyers will take any questions you may have in terms of that legal journey of yours. And by the way, just to clarify, this is on UK startup law, not other jurisdictions. And two, we are not dishing out legal advice. All three panelists will simply try and answer based on their experience and their opinions. Now, as far as how this works, we'll go through some quick introductions, open it, or actually just before opening it for questions, my panelists will kind of give us their do's and don'ts when it comes to early stage legalities. And then after that, we'll open it for questions from the floor. For those of you that are tuning in via other social media platforms like LinkedIn, YouTube, Facebook, wherever else we may be live at the moment, please be aware that unfortunately we're unable to monitor your questions there. So if you do want to ask us anything, you'll have to join us here live on Microsoft Teams. That is quite easily done. All you have to do is just click a link. So we've put links on all those platforms. There's links to join us live here on Microsoft Teams. It's a quick registration and then you're in. So please feel free to do that. On the other hand, if your questions today are not on the legal side of things, please save them for the other sessions we run. So to give you an idea, we run 4 weekly sessions. On Monday, it's talent, Tuesdays, product and tech, Wednesdays, growth, and Thursdays, fundraising. And now we also do 2 monthly ones. One, as you can see today, on legal, which is the second Friday of each month, and one on finances, which is on the third Friday of each month. And they're all from 12 to 1 p.m. UK time. They're all live audio. They're all free. And they all have brilliant panelists like the one today. So whilst you're getting ready for your questions, by the way, in terms of who will be given priority to ask questions, are the people that will put the question in the chat room first. And then I will pull you up and unmute you to ask the question. So without further ado, my name's Anton Call. I'm an Albanian in London, working with startups normally right after they get investment. I embed within their teams and help them hire and keep the right people. I do some growth advisory work, and lately I've been helping some angels and family offices with their due diligence and assessment. Now, Ishita is the lady of the house, so please go first with your introduction, and then Harry, and then Kevin.
Hi, everyone. Good afternoon. I'm Ishita Luthra, and I'm working as a senior lawyer with Sprint Law UK. I'm a dual qualified solicitor in the UK and in India, and I have over 10 years of experience in advising companies on private M&A, general corporate work, commercial contracts, and GDPR. My clients are primarily early stage startups and small and medium business owners. Yeah, I'm super excited to be here today, and thanks, Anton, for this opportunity.
Well, thank you for joining us. Thank you, Ishita. Harry.
Good afternoon, everyone. I'm Harry. I'm an employment partner at the London law firm JMW. I've been advising startups and fast growth companies for 10 years or so across all different sectors, particularly tech and life science. I advise clients on all things employment and people, so all throughout the employment life cycle, so recruitment, employment contracts, internal processes during employment, employment termination, and then post-termination restrictions and any potential litigation that may flow from that employment. Excited to join the panel today and answer any questions anyone may have.
Thank you, Harry. Yes, please, Kevin.
I'm Kevin Withane. I'm the co-managing partner of Impact Lawyers. We are in the process of getting our regulation, but essentially the combination of two legal consultancies, Ikigai Legal and Victoria Hall. So currently we offer corporate commercial with a focus on startups and tech. That's my area of specialism. So I'm 22 years qualified, originally qualified as a barrister, and then went into private practice. I've lived and worked around the world, including China, Hong Kong, Russia, and the US. I've done all sorts of transactions from big to multi-billion-dollar transactions, including taking companies public in Hong Kong and in the UK. The only continent I haven't done a deal on is Antarctica. And I'm super happy now to be helping a lot of startups. I also run a community called Diversity X, which focuses on supporting underestimated founders. And a lot of my clients come from there. And I'm excited to answer your questions and be part of this brilliant panel. Thank you, Anthony.
Wow, thank you very much. Well, we've got an absolute stellar panel today with us. So if I were you, I wouldn't waste time to wait for this. By the way, there are no right or wrong questions, and there's no need to be shy. What we're here to do today for the next 15 minutes, we're here to help UK startups with any questions you may have on the legal side of things. So anything from incorporation to founder agreement, shareholder rights, IP, term sheets, compliance, regulatory requirements, NDA, GDPR, employment laws, legal documents, contracts, co-founder, investor, board disputes, and all that jazz. This is the place to be if you need help with the legal side of your startup. All you have to do is put it in the chat that you want to ask a question and write the question there, and then I'll unmute you and give you the floor. By the way, if your questions are on other matters, please then save them for the other rooms we run. So we're currently doing 6 regular sessions, 4 weekly and 2 monthly. Monday, it's talent. Tuesday, product and tech. Wednesday, growth. And Thursday's fundraising. And then second Friday of each month, it's legal. And third Friday of each month, it's finances. They're all from 12 to 1 p.m. UK time. They're all live audio, which means you can join from anywhere. And to those of you that are tuning in that I can see now on LinkedIn or Facebook or YouTube, please be aware that unfortunately we're unable to monitor your questions there. So if you do want to ask us a question, you'll need to do it interactively and join us here on live audio on Microsoft Teams. And I've posted a link on each of those platforms where we're live streaming now. All you have to do is just click that quick registration and then you can join us. But before we start taking questions, or as you're writing your questions, I would love to go into quite a bit of length, especially since it's our first session, with our lawyers on stage, in terms of some really important stuff when it comes to do's and don'ts. So from, pre-incorporation to incorporation to agreements and so on. So perhaps we can start with Kevin and then Harry and then Ishita. By the way, don't worry, take your time. If you can think of maybe, 3 do's and 3 don'ts each, that would be great. But if not, just as many as you can. Thank you.
So 3 do's pre-incorporation is when you're incorporating, if it's just one person, have a look at Tide Bank, because they do it for 14 quid, whereas now it costs £50 to set up a company. You can do it yourself. And there's lots of free guides available to Google to how to do it. I'd say also when you're setting your shares, have a higher number of shares, but for less than a penny. So decimal points, maybe 4 or 5 decimal points out. So
why is that, Kevin?
Because if you set it for £1 or something, you end up, and like one share, when you go for investment, you end up having to do a subdivision, which is much more work, and it could get confusing. If you do it already subdivided, you can have much more number of shares to be able to allocate and not have to do the subdivision. So it works out a lot better. I literally just filed a SHO2 before funding round that I'm working on with a client, because
And what is an SHA2?
that's the document for subdivision. So we had to then like do board resolutions, a written resolution. So it adds more admin. So if you set it up at the beginning, it's a lot. You don't have to worry about that admin later, slowing you down, which that has in this case slowed us down a little bit.
Thank you very much.
Yeah, go on. That's it.
No, carry on. Any other stuff that you can think of that is important, or that you see going wrong, or that you see done well when it comes at those early stages, Kevin?
Yeah. Certain types of templates are okay, but using certain platforms that they really focus on, like, their templates are rubbish. You end up coming a cropper. So it's better to get legal advice, and ChatGPT is not a lawyer. While it can do quite a lot and it can give you an outline, it can't do draft detailed agreements. Because if it did, we'd all as lawyers be using it all the time. And we're not, because it's not good enough. So I would say seek proper legal advice. Like, just in the same way, you don't want to mess up your finances, and so you go to an accountant. It's exactly the same thing.
Thank you very much. Okay, we'll go to Harry now, but might come back if you think of anything else, Kevin. But we'll go to Harry now. Harry, when it comes to employment, what are things that you think are absolutely crucial that founders need to do from, if not day one, if not before day one, at least from day one onwards? And also, what have you seen done wrong, or you often see done wrong, and what you often see done right?
Yeah, of course. So I'll start with the do's. So the first one is really to make sure you're always acting decisively when it comes to hiring, but also when it comes to terminating your first employees. In the UK anyway, there are no real termination rights and termination liabilities until an employee has been with the company for over 2 years. So often one of the mistakes that founders can make is they bring someone on, they can see from kind of day one or soon after that it's not working, because you really need to be a particular type of person to be successful in an early stage company. But then they don't act decisively, and it obviously impacts cash flow because you have to pay that employee, but they're also not doing what you want them to do, and it's not helping the business to grow. But founders can often be nervous about terminating if they're worried about liability. But so long as you pay the employee the correct notice in their contract, and you can obviously have shorter notice in probation periods as to after, there is no real legal recourse for that dismissed employee until they've reached 2 years service. So you're much better off for your business to act decisively if you realize that a hire has gone wrong. And that can happen, especially with early stage companies. Then my next do is something that Kevin touched on about having appropriate documentation. So one document that I often see with my startup clients is almost a founder agreement. And what that typically looks to do is almost act as a comprehensive document dealing with the founder's equity in their business, but also outlining the terms of employment. And really the problem with that is you end up merging shareholder rights and status with employment status, and it proves difficult to separate the two. So ideally you should have one agreement in place dealing with the shareholding and the equity in the company, and then a completely separate agreement dealing with the terms of employment. And whilst at the outset that may seem like more work because it's two documents, certainly in the medium and long term it's a much cleaner way of doing it. Talking about the specific employment contract, I'd say the number one priority, especially for startups, is making sure that the key interests and assets in the business are protected through the employment contract. So that would obviously be the intellectual property that's created, because what you don't want to do is have your first employee come in, create some great IP for the business under kind of your instructions, and then them later try to argue that actually now they're leaving, they own that IP. So it's important to have express IP clauses in the contract to make sure there's no ambiguity. Luckily, law says that as long as it's created in employment, it will belong to the company, but it's always much better for founders to be able to expressly point to a clause that says that. And then also post-termination restrictions. And whilst it's not always that positive to be looking at what the termination provisions and arrangements are when you're starting off employment, it's similar to the need to have a prenuptial agreement at the start of a marriage, because you do just need to make sure you protected yourself from the outset if things don't go right in the end. So in an employment contract, you can protect confidential information once the employment ends, your clients to make sure they can't be poached, and your employees. So again, that can all be documented in the employment contract and is very important. My final do is not entirely legal, but it's definitely something that I always mention to my startup clients. It's that there is a real ecosystem and support network with startups, and it's very difficult. And as Anton knows and often says, a lot of startups do fail, unfortunately. That's just kind of the nature of the world that we operate in. But use your support network, use people who are doing something similar to you as collaborators, rather than just viewing them as competitors and keeping yourself very isolated, because everyone encounters similar problems. So the more you can lean on others, the better. Anton, do I have time to go through a couple of don'ts, or do you want me to come back to that?
No, carry on.
Okay, perfect. So just a few don'ts. So the first one is to not necessarily look to hire for the long term. You should always hire for the stage that your startup is at the moment. The example I always give for that is someone coming in to manage the finance of the company. So you don't necessarily need to look to recruit kind of a chief finance officer for a startup that may have 5 or 10 employees and kind of very simple remuneration practices. You should really just be looking for a finance director and then, or finance manager. And then as your company grows in maybe a year, 18 months, at that point, you can look for someone who may have better expertise in dealing with the size of company you are at that moment. So you don't need to bring someone in to almost future-proof where the startup may go in 18 months or 2 years. The next don't is, and this is a hard one for founders to sometimes accept, but it's not to expect your employees to have the same founder passion and same founder work ethic that you have. Whilst you may see it as kind of the be all and end all and your life and all encompassing, there may be some employees who do a very, very good job in discharging their duties and obligations and work their contracted hours, but they may not work weekends and they may not want to work until midnight every night. And that doesn't mean that they are not very valuable to the business. So it's just having realistic expectations, because I've seen a lot of founders get rid of very, very good talent simply because they may not match the work ethic of themselves who've been in that business and dealing with that specific product for years. The next one is to not necessarily look to hire someone who is very similar to you, or even someone that you would think, oh, they could be my friend, because what you're looking for is actually a diversification of skills and a diversification of experience. And it can actually be very helpful to look to employ people who have different skills, different experience, and even different interests to you, to then make sure that you can all collaborate within the same company, which can really help kind of with ideas and approaches to the problems you may encounter. And then the final one, which again is something that a lot of founders fall foul on, is you need to be paying yourself the national minimum wage, at least in the UK, as soon as you become an employee of the company. What we see a lot of founders do is say, I don't want to take money out of my own business. I've got enough savings to survive on. I want to keep as much cash in the business as possible. And therefore, they voluntarily and expressly waive the right to the national minimum wage, which is illegal and actually does have criminal liability attached to it. And where this can really cause the founder issues is when they're then looking for future investment. One of the main things that can come up in a due diligence exercise is this point around what remuneration the founder has been receiving since they have been providing services to the company. And it's not sufficient to say, it's okay, I didn't need money, or I didn't want to take money out of the business. That can still cause a lot of issues and may actually deter investors from becoming part of the business because of that existing liability. So yeah, they're just a few do's and don'ts.
Hang on. So what you're saying is that if a founder chooses not to pay themselves for a certain period, they are committing something that is against the law.
Correct. Because you are not allowed to waive your right to national minimum wage, and therefore you need to be receiving national minimum wage for all the time that you are providing services to the company.
Have you come across anybody being penalized for such, and what is the normal penalty for such?
So it can be criminal. I haven't seen it go that far, but I've absolutely seen it cause considerable problems for startups when they're looking to seek investment, because it can absolutely deter investors in investing in a company that has that problem. There's obviously indemnities that you can potentially do to protect, or you can make almost a retrospective payment potentially, but that's not kind of a great way of going about it. And to be honest, it can show potential investors who are investing in the founder, they want that founder to be kind of on the ball and aware of employment obligations and things like that. And if they've kind of not looked into the point on national minimum wage, that may not be a great look.
Yeah, can I add to that, Harry?
Of course.
Just to confirm though, that's when the founder has become an employee, so there'd be a clear employment relationship as opposed to them still just being a director, but there's no employee. But also in the investment docs, we typically would have a requirement for a warranty that all taxes, including national insurance, income tax, and any other taxes, have been paid and up to date. So you would have to disclose against that and either rectify it, or, as Harry said, it could actually just put the investor off.
Yeah. And just to say, Kevin, obviously, yes, an employee is absolutely entitled to national minimum wage, but it can also be a bit wider than that. And it can actually also sort of capture workers as well. So there can also be grey area. And it's not just if you've got an employment contract. Even if you don't, you can still be an employee or a worker that's entitled to national minimum wage. So you can still have problems. So it's not a way to get around this by just saying, you know what, I won't have an employment contract, therefore I'm not entitled to national minimum wage, and therefore this won't be an issue for me. It can still very much be an issue.
So even if you're just a director?
It depends on the level of services and what you're doing for the company, and kind of just like any worker status query, there'd be a series of tests that you would look into to establish if national minimum wage was payable.
Wow. Is there a website, a government platform or anything like that where people can check for free, or would they need to pay somebody for that?
No, so you can look on HMRC's website. There's something called CEST, which is CEST.
Can I ask you a favor, please, Harry?
Mm.
Would you mind? I have tagged all three of you on LinkedIn. Would you mind just looking back to that tag and just put that website CEST that you mentioned, to just put it there so that for others that may listen to our session later, they can see it. Would that be all right?
Yeah, of course, I can do that now.
Thank you, buddy. So carry on.
No, so the CEST website is used to see if someone is self-employed or not. And if you give kind of reliable answers, you can get an indication where it will come up and say you are genuinely self-employed or you're genuinely an employee. And obviously if you get an answer to say you're an employee, then you will be entitled to national minimum wage. And that's how you can see, because it weighs up all the factors about whether you provide the services personally or whether a substitute can do it, all things that you look into for employment status tests.
Perfect. Thank you very much, Harry.
No
Ishita, what are your main sort of do's and don'ts, especially on the IP side, but other stuff as well?
Yeah, I'll probably start with the incorporation and pre-incorporation perspective. So these are really simple do's. Basically, when you start your business, when you have an idea, right? Say, for example, you have a coaching business, but you don't have many clients. You're just starting off. You just have an idea and you want to think about a name. So you have to ensure that your business name does not infringe on anyone else's trademark or anyone else's brand name, etc. So you can go to the company's house and check for names and see if that name is already in use. There are a lot of dissolved companies, you know, and the name could potentially be available. So one thing is that first do is check the business name properly, because going forward, if your business is established well, then you're going to, you know, focus on your branding. And at the end of the day, it's an asset to your company. You know, IP is intangible asset. The other point is, what legal structure are you going to use? Are you going to operate as a sole trader or a partnership or a limited company? So if you are, say, like I said, a small coaching business and you have a partner, you know, or a co-founder, then whether partnership is the right structure for you, or if you're looking for investments in the future, it's advisable to set up a limited company, you know, because investors want to invest in a limited entity. And also it protects yourself from personal liability, because a company, a limited company, is a separate legal person. So you got to ensure that you have the right legal structure. The third do I'd suggest is, if you have a co-founder, you need to, you know, be clear about what their roles and responsibilities are. If you're giving away equity, do you have a proper co-founder agreement which sets out how much they own, what are the roles and responsibilities? And if things go fine, then great. But if things don't go well, then that co-founder agreement needs to have exit clauses. Like, how are you going to provide exit to your co-founder? Those, I think, are really crucial, because, yeah, setting up a new business, you know, a startup is really cool, but you got to be really mindful about these small things, because they can become bigger issues if not dealt with properly, you know, in the early stages of your startup journey. In terms of don'ts, I'd like to focus that, like Kevin mentioned about the cap table, I would say that don't commit giving away too much equity too soon in your business, whether it's to an investor or to an employee or to your contractors. You should take control of your cap table. And the more stake you have in the company, you know, it's likely you'll have more control in the company. So when you're in your early stages, you shouldn't give away too much equity upfront or commit. Like, for example, I've seen a lot of startups, they say, okay, I've got a contractor on board, or I've got an employee on board. I'm not paying them anything. I'll give them 15% equity or 25% equity. You got to make sure that the work that they are going to achieve for you or do for you is, you know, it is equal to that much equity that you're giving. So I think founders give away too much equity too soon, and which in essence means that you're handing over too much control of the company to that person. I mean, there are ways about it, like about issuing another classes of shares with voting rights or without voting rights, etc. And we can discuss that separately. But yeah, the don't that I'm trying to focus on is that don't give away too much of it. The other don't I would like to focus on, or say that You spoke about templates earlier on in this discussion. I'd say I have a thing about templates. You have loads of websites that give you templates for a shareholders agreement or a subscription agreement, investment agreement.
We've lost you, Ishita. Can anybody else hear Ishita, or is it just me?
I can't hear her.
I can't hear her.
Ishita, we can't hear you. What you might want to do is perhaps leave the call and then rejoin, or something along the lines. Can't hear you, Ishita. Right. Okay. Well, until Ishita comes back, perhaps Harry and Kevin might want to pick this up on the templates part, because I keep getting, literally, I cannot think of a single. All right, let's not over exaggerate it, but I cannot think of going to 2 events that I haven't been asked at least once by people, where can I find a template for this agreement or that agreement, or anything like that. So where can founders find half decent half decent templates that perhaps that are free, or maybe not free but at least quite cheap? Any thoughts on that? Let's start with Kevin, since I think you're unmuted, and then we'll go on to Harry, please.
Yeah, it really depends on the type of thing. Like I strongly recommend not doing it for your investment documents. Like, you can get some templates, but you need to understand what you're changing, because particularly if you're getting investors with SEIS, or who are expecting SEIS at EIS, you don't want to mess that up. So you should go to, you can either get a template and then go to a lawyer to help you, or go to a lawyer. The costs are going to be relatively the same at the end of the day. For things like basic like terms and conditions for websites and privacy policies, ICO, with the, most companies will have to register with the Information Commissioner's Office. They now do a privacy policy generator. It's free. It's not bad. Like, the more technical your platform, the more information it is, you might need to go and get paid a lawyer to look at it and draft it properly. But at the beginning, you're just getting your website up and running, or your app. The ICO generator is pretty good. You can look at Simply Docs. They have, look, it's not brilliant, but usable templates. I guess if as you become more sophisticated, or if you're like, needs are more sophisticated, like for instance commercial agreements, you should go to a lawyer. But for sort of basic policies, procedures, Simply Docs can do that, and I think the subscription is pretty cheap, and certainly less than something like some of the platforms out there, the well-known platforms out there. Employment agreements, I still think you can get some good, there are some good templates out there, but I still think you should get them checked with a lawyer, even if it's just, I have this template, I've filled it out, can you please give it once over? And I certainly think you should do that when you're trying to bring on consultants and or advisors, and you're using a type of consultancy agreement, because you want to ensure that that agreement is a proper consultancy agreement, and they're independent, and it won't act as an employment agreement. So in that situation, again, if you're going to use a templated version, go and get it checked by a lawyer, because you really don't want the risk of thinking you're bringing on a consultant, but actually it's going to be treated as an employee. Harry, over to you, mate.
Yeah, so I absolutely agree with that. That's probably the biggest thing that you want to avoid, is the wrong classification of an individual. So yes, if you're looking to bring on a consultant in the hope of, I guess, saving some costs, because a consultant won't be entitled to some of the benefits that an employee would be entitled to, such as paid holiday, national minimum wage, as I was saying earlier, we need to make sure that it's not just the document that says a consultant, because you can actually look behind the document and see how the individual actually operates in practice. And if they're working for you 5 days a week, 9 to 5, and you're pretty much treating them like an employee, it's not enough that you have a document that says they're not an employee. It can actually go beyond that. In regards to kind of free resources for employment contracts, there's ACAS, which is a conciliatory mediation free service that employers and employees can use if they get into a dispute, but they also have some resources that may help. But yeah, I also agree with Kevin that it's all about making sure you do have the correct documentation. Unfortunately, free documents are very rarely as good and as effective as documents that you have to pay for. But there are some law firms that are specifically aimed at startups, and they may be more cost effective than kind of a general law firm that offers documents for all sizes of companies. So I'd have a quick Google to look at some startup specific law firms if you're looking for kind of a quick and easy employment contract.
Thank you very much, Harry. Ishita, are you okay to talk now? Can you hear us? I think something's not right with Ishita's connection. Right here, Daniel, I've unmuted you so you can unmute yourself and turn on your mic. You've put 2 questions in the Q&A. I'm sorry, for some reason I missed them. So please introduce yourself and then fire away with whatever question you have for us. Perhaps since you've got 2 questions, if you want, you can ask first one and then the other. Take it away, please. Can you hear us, Daniel?
Does it work now?
Yes, it does. Now we can hear you. But maybe if you can speak a bit louder, please.
Okay. Yeah, it's like the microphone was not working. Sorry. So I'm the co-founder of a edtech startup in London, and the name is Bridgely. We do technology for learning methods. And when we registered the company at first, we did the mistake that Kevin was mentioning in the beginning of the value shares. They were set up like those few shares at a value of £1 each. He was mentioning that the subdivision process is complex. I was wondering whether that's something we should take care of as soon as possible to use the value, because what we did was to reduce the amount of shares, because in the beginning that was a second mistake. But what are the right strategies if you've made that mistake to start with?
That's a very good question.
Firstly,
thank you.
It's not a mistake because it's like it's completely fine for most companies, but where you tend to be raising, you're allocating shares, and the price can become too high per share sometimes, so you subdivide them. There's a number of reasons for subdivision, so it's not a mistake. It's not complex. Basically, when you want to change it, you need to do a board resolution, and then you need to go to also a written resolution of the members. And then once those have been signed and proved by both the board and the members, then you need to complete and file the SHO2, which sets out whether it's consolidation or subdivision, the class of shares, how many shares there are currently, how many you want to subdivide them into, and what the nominal value, the new nominal value is. And then you do a statement of capital on the same form. You sign that, and then you upload it to Companies House.
So the result of this process would be the equivalent to have it done for the start. There's no remaining differences.
No. It's not a difficult process, but it's easy to make mistakes. You should also, once you've done that, by the way, you should, everybody, I see this all the time when I'm representing clients on funding rounds, and the VC says to me, can you ask your clients to send us the statutory books? To which they go, what the hell is that, Kevin? In the old days, when you used to register companies, like most places would send you like a proper book. Now it's all electronic, everybody forgets about it, but you need to maintain your statutory books, and it's a register of directors, a register of members, a register of allotments and transfers, the PSC, and you need to maintain that. So every time you would do a change on Companies House, you should also record it in those books. And I often spend time chasing up the information, and then sometimes the information that I'm given isn't reflected in Companies House, so you have to go back and make changes. So these are all corporate governance, and it just means, like, you just need to make sure that when you make changes in Companies House, you also make sure that they're consistent with what's in your statutory books. I actually have a template one that people can use to get started to do that as well, and that's free.
Perfect. Kevin, can I ask you a favor? Is that online or the template?
No, because it's going to go on our new website, and that's not live, or it's not up and running yet. But if they email me, or they LinkedIn with me and ask for it, I'll ping it across.
I hear. What I was thinking is, if you have that somewhere on Google where people will need to register with their email, and you have it on Google Docs, that means you can put a link to it, and you'll still see who's viewing it. Is that something?
That is what we're working on, with our website designer.
Would you mind putting that maybe in the so on LinkedIn? I've tagged you and Harry and Ishita. If you've got that link, that would be brilliant, because I'm sure people will see this later, in the recording that is on LinkedIn, and they might find this useful. And you also get to capture their emails for future comms if you need to.
Sure.
Top man, thank you very much. Yes, Daniel.
No, thank you very much. That was very clear explanation. I will reach out for that template.
Brilliant. And Daniel, you asked another question.
Yeah. The second.
You asked it. Yes.
The second question was, once the company is registered, there might still be a year or more before generating revenues. And also before having paid employees. Like in our case, it's 3 co-founders working on it at no pay, like bootstrapping so far. Are there any legal responsibilities regarding government bureaucracy, like tax returns? As far as there's no economic activity, I think is not necessary. Are there any other things that one should keep in mind? It might be also good advice in terms of deciding when is the right time to then register the company or not, if there's a lot of bureaucracy to do around it and it's not necessary.
Yeah, shall I take that?
Go on. Yeah. Carry on.
Just because you're not generating revenue, you still have to do returns. So you'll have to do your confirmation statement annually. You have to do your accounts. Even if there are no accounts, then you would file dormant accounts. If there are any sort of transactions, then it will be small or micro business or bridged accounts, but you must file them, because if you don't, even if you're not revenue generating, you will get fined, and the fines rack up really quickly. So make sure that this information, by the way, of when you need to file things is very visible when you go on your Companies House page. You also need to do it with HMRC. Even if there is nothing, you still need to file. Like for corporate tax, it'll just be 0, but you still need to make sure you file that again. You can get fined, and it's not worth the fines. And it doesn't look great when you go for investment. And you need to ensure that the on Companies House, your PSC as well. So that's persons of significant control, or persons with significant control. You need to make sure that's up to date and file that.
Thank you. I think there's something about if you register in the middle of a financial year, then the first year you don't submit some of those. Is that right?
Well, it's based on your accounting year.
Okay.
Kevin and Harry and Ishita will know this better than I do, but it doesn't matter at what stage. You should always do at the end of the tax year, or the season, whatever it is, basically.
Right.
You should always do that, and also is it what is it? So you've got the tax, and
Hi.
the other one is for directors. Yes, go on. Sorry.
So you got your person.
Sorry. Yeah, sorry, I'm having technical difficulties. Yeah, I think it's called the accounting reference date for the year. Yeah. So basically, the day you set your company up, and then 12 months from there is your accounting reference date, or the year that's called, and your financial or tax year runs from April 6th to the following April 5th the next year, right? So there's a difference. You can align your tax year and your accounting year as well. So if you want to do that, speak to your accountant. They might be able to help you with that. Does that answer your question, Daniel?
Yeah, okay, thank you.
Thank you very much to all three of you. Ishita, did you want to add anything from the do's and don'ts you were giving us earlier, or shall we move on to something else?
Well, what I was trying to say, Anton, was that do not rely on templates, because your contract needs to reflect exactly your commercial arrangement with the other side. And as a small business owner, you need to be aware of your liability and the level of risk. So if you're a service provider, what's your liability under the contract? And if you're a service receiver, then what's your risk? And as a small business owner, you might not think too far, but what if there was a breach of contract, and if you were to go to court with that contract, that template, so getting advice, is very important, because you need to make sure that your contract is enforceable, even if it goes to say a small claims court. You can't just have a template and then use it across your commercial arrangements. That was the point I was trying to make then, and then the Wi-Fi turned off.
No, that's fine. Thank you very much for that. Really appreciate it. I'm going to do a quick reset of the conversation, and then we'll go to a question that was sent in to us. So for those of you that are tuning in via LinkedIn, YouTube, Facebook, or any other social media platform, please be aware that unfortunately we're unable to monitor your questions there. So if you do want to ask us anything, you would need to join us here on Microsoft Teams, where it's interactive, live, and audio only. Today, we're helping startups with whatever questions you have on that sort of legal side of running your startup. We've got 3 brilliant lawyers with us on stage today. And by the way, your questions could be on anything from incorporation to founder agreement, shareholder rights, IP, term sheets, compliance, regulatory, NDAs, GDPR, employment law, legal documents, contracts, co-founder, investor, board disputes, and all that jazz. There are no right or wrong questions for that matter, and it's a learning curve for us all. If your questions, however, today are not on the legal side of things, please save them for the other conversations we have. So we run 6 regular events. 4 of those are weekly: Monday's talent, Tuesday's product and tech, Wednesday's growth, and Thursday's fundraising, and 2 others that are monthly: the legal one, which is the second Friday of each month that we're doing today, and the finances and accounting and taxing and all that jazz one that we do on the third Friday of each month. They're all from 12 to 1 p.m. UK time. You can RSVP to them via our website, startup2scaleup.club. And actually, the best thing to do if you want to keep up with the alerts for events is to join our WhatsApp group that you can find on our website. But now, without further ado, perhaps we can go to one question that was sent in to us. I think it was from Cornwall. Yeah. So this lady that runs a creative agency in Truro, Cornwall, that is, she asks, as a co-founder of a creative agency, I'm considering selling a portion of my shares to a new investor to bring in fresh capital. However, my other co-founders are against the idea. What are my legal options if I want to move forward with the sale? And how can I maintain the agency's cohesion and long-term objectives during this situation? I think when it comes to our legal Q&A, this is the one session out of all the others that we do that you definitely want to be here live, because I'm sure there'll be quite a few follow-ups from our lawyers. But nevertheless, perhaps we can start with Kevin, then Ishita, and if Harry wants to add anything, although this isn't really employment, but still more than happy for you to add anything you want. Kevin, take it away, please, buddy.
Sorry, Mike, can you hear me? Hello?
Yes, we can.
What
Yep,
was that
can you hear
question?
us?
My internet's breaking up a little bit.
Oh dear, that's right. I'll put it in the chat anyway if you'd like to have a look, but I'll read it out loud. So this is a creative agency in Cornwall, and this lady asks, as a co-founder of a creative agency, I'm considering selling a portion of my shares to a new investor to bring in fresh capital. However, my other co-founders are against the idea. What are my legal options if I want to move forward with a sale? And how can I maintain the agency's cohesion and long-term objectives during such transition?
Depends on what the article. Can you hear me, by the way?
Yes, we can.
Yeah. Okay. It depends on what your articles say, whether you have a shareholders agreement and what that says. Usually your articles, even the model articles, will have what the requirements for permitted transfers and what that looks like. If you have issues, if your co-founders have issues though, then doing it and proceed, even if you are allowed to proceed with that transfer of shares, you are potentially causing a lot of issues with your co-founders. You've got to weigh up whether that is worthwhile. I don't know what the issues, what the stakeholding is between the different co-founders, so it's hard to like know whether you're a minority, a majority shareholder, if you're all equal. Also, there potentially is tax issues for you individually, and for potentially for the new investor as well. So you may want to consider whether transferring shares is the best way to do it, or whether you issue new shares in the company. So there's some of the key things to think about.
Thank you very much, Kevin. Ishita, any thoughts on that?
Yeah, I'd like to add that I think the person who's asked the question needs to be clear whether this new investor, what's the mode of their investment. If you are transferring shares to them, then in essence you get the proceeds of the sale. But if they are putting capital into the company, then the company gets the funds. So there are two things. There's a transfer of shares.
Can you elaborate on that, please?
Yeah, so one is transfer of shares and one is issue of capital. So when a company receives investment or funds, then new shares are issued in the share capital of the company. Whereas in a transfer, suppose there is ABC shareholder and A transfers a portion of their shares to X, then the exchange of funds is between X and A. So the company doesn't get those funds. So the question that they have asked is that they are considering selling a portion of their shares to the investor. So in that sense, the other two shareholders might have an issue because, you know, the company is not getting any funds, right? And as Kevin mentioned, obviously you have to check your governing documents, the articles of association or the shareholders agreements, if any you have, because there are rights called preemption rights, which don't allow the company to issue new shares unless all the other existing shareholders have agreed to that. And if the company does issue new shares, then the existing shareholders have an opportunity to subscribe to those shares. That is your preemption right. And the other one is also called a right of first refusal, which is if one of the shareholders want to sell their shares to a third party, they need to give the other two existing shareholders or the other existing shareholders an opportunity to buy those shares first from the selling shareholder. Does that make sense?
Yes, it does, Ishita, and thank you very much. That is some brilliant stuff.
Also,
Yeah,
just to
go ahead,
follow on
Kev.
from that, Anton, also you need to check whether they're drag and tag rights as well.
Yeah.
Which could drag
That
all.
is brilliant. Would either of you have any articles out there that touch on these three things, or some of them that you can share on that LinkedIn post that I mentioned?
They're so bespoke to particular companies when you do it properly.
Yeah.
Okay.
Because they have things like other things like, you know, I mean, they're all publicly available articles, right? So you can go into a startup that you think or a company that you think similar and have a look at theirs.
I see.
But they tend to be much more bespoke because it depends on the rights that may have been negotiated between parties.
I hear. That makes sense. Yes, Ishita, sorry.
Yeah, and to add to that, to Kevin's point, is that, generally companies adopt model articles, you know, which are prescribed by the Companies Act. So shareholders already have those preemption rights under law. They are called statutory preemption rights. But these tag and drag along rights, they are something which parties agree on a contractual basis. So they are typically covered in your shareholders agreements or your founder agreements, but you won't find them in your model articles. So the articles have to be bespoke, like Kevin said, if you want to include these tag and drag rights. But the preemption rights are pretty much available to the shareholders in any company if they've adopted model articles.
I see. Well, thank you very much to all three of you. My God, this has been a serious minefield on one hand, but on the other hand, very much informative and extremely useful. So I'm grateful to all three of you. We are now 1 minute over the line, which means we need to shut shop, but I would love to hear from yourselves any parting words that you may have. So perhaps we can start with Harry, since the last question wasn't really in his domain. So Harry, if you'd like to go first, and then Ishita, and then Kevin, please.
Yeah, of course, Anton. I would just say, obviously, we've discussed quite a few thorny issues here, and it's not to put off any startups or anything like that. So just remember, it's an exciting adventure. Yes, there are things to avoid, and that's why people like us are here to help, but it's exciting, and wishing everyone the best of luck on the adventure.
Thank you very much, Harry. Yes, Ishita.
Yeah, I'd like to say that you know, you should work on your idea, you should get your business running, but legals is something that needs to get sorted. It must be done. So get your legals correct right from the start, and just keep them in the cupboard, and it's only when you have an issue, take them out. So yeah, all the best to everyone.
Fair enough. Thank you very much for that. And last but not least, Kevin, please.
Get proper advice. Like you can try and find basic information by Googling or using ChatGPT, but nothing beats getting and investing in some quality legal advice. It doesn't have to be expensive. There are companies that can do it cost effectively, but it's better to speak to a qualified lawyer that knows what they're talking about than trying to work it out yourself and finding later down the line you've made mistakes, because that can cost you time, money, and potentially investment for your startup.
That is brilliant advice from all three of you, and I really appreciate that. Okie dokie, we are now 3 minutes over the line, which means we need to bring this to a final. So a quick reminder to everybody that tuned in via other platforms like LinkedIn, YouTube, Facebook, and so on. Please be aware that we are unable to monitor your questions live, which means next time, if you do want to ask us anything, you'll have to join us on Microsoft Teams. It's audio only, which means you can join from anywhere, despite whatever you're doing. We run 6 regular sessions. We run 4 weekly, so Monday's talent, Tuesday's product and tech, Wednesday's growth, and Thursday's fundraising. And then we run 2 monthly. Second Friday of each month, today was on legal, and third Friday of each month, next week, it's on finances. They're all from 12 to 1 p.m. They're all free, and all of them have some of the top people in our startup ecosystem on the panels. Now, if you want to RSVP to any of them, please do that via our site, startup2scaleup.club. Otherwise, also a good idea is to join our WhatsApp group, which you'll find on our website, and you'll get alerts for all future sessions. As far as my parting words are concerned, just remember, the startup journey can be both difficult but also quite exciting. So try to have some fun in the meantime, and be kind to yourself and other people too, for that matter. And also stay safe. Again, huge thanks. Have a great weekend, and God bless you all. See you next Monday for Startup Talent Q&A. Thank you again, panel.